Rhonda, I am so happy to be having this conversation here with you. As we discussed earlier, I was really just interested in getting some good information out there so that people can have a clearer perspective on what to do when they fall behind on their mortgage payments. As you know, as a veteran in this, being around since 2008 when the crisis hit, there's a lot of information. In today's age, just social media, you can get a lot of bad information. And I thought it would be a good idea to just get on here with you and give people some good information. So thank you for joining me.
Oh, I'm glad to be here. I've been practicing in this area of law for about 18 years now. So as you know, with you and I've been through a lot just in the last 5. I've seen a lot. So what we're going to talk about, I guess, is from a perspective if you're dealing with a mortgage in Alabama, but a lot of the stuff's going to apply generally that we're going to talk about.
Right. All right. So I'm going to pop up this little graph I came with not too long ago. Again, where do you start? Somebody is behind. Oh boy. I mean, there's so many different scenarios, right? Somebody just got behind on their mortgage. They're not sure what to do. Which of the many rabbit holes would you recommend somebody, to start? Just again, just give me your perspective, Rhonda.
Well, so my perspective is when we say we've got behind, how far behind are we? If we are 4 months behind, then we really got to crank things up and try to avoid a foreclosure, as you know. If you're just, you're behind a month, then you're going to reach out to your servicer. You want to talk to your servicer and you want to try to figure out what are options, what things can they do to help you with whatever payments behind. If you're coming to me, then I'm going to want to know, we have the servicer and then we have whoever owns the loan or what we call the investor in the loan. So I want to know who your servicer is. So then I kind of know how you're going to deal with that servicer, how they deal with consumers. And then we want to know who the investor is. And why do we want to know who the investor is, Bobby?
I mean, the investor, right? Again, we use that term investor loosely, but what we really want is that entity. Well, what I want in my world is the entity that's ruling the actual modification rules. Many times we can determine that many investors have published guidelines, and we're very familiar with them. It's a book. You read it. You practice in the area long enough. You learn the intricacies of it, and you can really help somebody resolve their loss mitigation aspect of it as far as the loan modification goes.
Yeah. And so when we're talking about loss mitigation, then of course the investor or the entity that's controlling how we overcome a default, how we can, if we need to modify a loan, if we need to have some kind of alternative to avoid a foreclosure, we're talking about those kind of things that we're looking at when we're talking about loss mitigation, just to be clear, so we're not using foreign terms. If someone is watching this and they don't know what that means, hopefully they do. But the bottom line is, if you're behind, then you want to seek out what are the options. And to know those options, then you need to know who's controlling the loss mitigation options that are out there. And like you said, there's so many different investors, like there's Fannie Mae that's an investor, there's Freddie Mac that's an investor. Those are published guidelines. And if you want to read them, they're out there. You know the guidelines and you study them. Then you have your VA guidelines, you have your FHA guidelines, and all those things are published and they're out there. So then it helps us have a better understanding of what we should expect the consumer to be told what direction the consumer could go, what options they would have.
Right. I'm so glad to be doing this with you because we've been down so many of these crazy rabbit holes in the past. And again, it's timing, right? Just like in a case of a bankruptcy case, right? There's timing issues. It's the same thing with the modifications, right? You may have lost your job, but you're getting another job in 3 months. Understanding the nuances of those programs and what they can do at every particular time is paramount. And as much as I know about mods, if I don't know, I don't know anything about going to court and that judge that you're going to be sitting in front of, so it's a lot of stuff to consider before you just jump in and send an application. And you want to have some kind of real perspective on what it's going to look like, the likelihood of the success.
And I know where you're going. You have a roadmap. If you know your investor, you know what programs are there, you kind of have a roadmap, and you try to guide the servicer with what information that you're able to provide. So if you're that point where you don't have a foreclosure sale set, then you've got time to work through those things. So number one that we want to emphasize, and you and I talk about this, like you said, timing is everything. If you're behind, you do not stick your head in the sand. I know it can be depressing, it can be overwhelming, but the worst thing you can do is stick your head in the sand and say, well, it'll just be what it is, and then come out and then trying to scramble around at the last minute. That's when you have to, if you're dealing with like an Alabama foreclosure, we're non-judicial, your foreclosure can happen in 21 days. Now you're coming to me to file something to try to stop a sale, or you're getting to a bankruptcy lawyer to try to stop a sale. And so now you're into litigation. Now you're into actually having to go and spend more money on bankruptcy or spend money on hiring an attorney to fight and stop a sale. Whereas if you get ahead of it, you know the path that you're going, and you have an open loss mitigation under review, then under the regulations, as you and I know, they're not supposed to go forward with a foreclosure sale if you get it in a proper time.
Right. Yep. So again, just like with everything, it really depends, especially in those judicial states where, like you said, the foreclosure can happen very, very quickly.
And we're using the term non-judicial just to make this clear. Non-judicial means they don't have to go through the court to foreclose on the property. They just have to publish it for 3 weeks in Alabama and hold a sale at the courthouse steps. So there is no lawsuit. You don't get served. You just get a letter that says, hey, there's going to be a foreclosure sale. Here's the date, and boom. Your judicial sale, like in Florida, you then got to go through the courts, and that's a longer process. But you're talking about something in Alabama, you cannot stick your head in the sand, or I have to do a lot more unraveling, which gets harder. The further along it gets harder.
Okay, so again, like you were touching on that, and if you don't mind, touch a little bit more on the bankruptcy. I know you don't particularly do bankruptcies, but
I don't.
As far as it relates to foreclosures, I know enough to give a little tidbit on bankruptcy.
So first of all, consumers that come to me are coming to me because they don't want to have to file a bankruptcy. But bankruptcy may be right for some people. I don't do it. But for instance, if you file a bankruptcy, then you get what they call an automatic stay. So you always, if you're going to file one and it has to do with a foreclosure, you got to file it before the foreclosure happens. You can't file it after, because at that point, the property's gone and it's not in the bankruptcy estate. So you always got to file before. If you file what we call a Chapter 13, which is where you're going to pay your arrearage of your where you're behind on your mortgage. So let's say you're 6 months behind. That 6 months of arrearage would go into your bankruptcy. And then in addition, all the other things that you have that are debts, they've got to go into. There's got to be a plan. You have to qualify. I'm no bankruptcy expert, but I'm just talking to you in general. You also have to, so you got to pay your plan payments each month, plus you have to pay your regular mortgage payments. And that's not easy. If you're already behind on your mortgage, probably had a financial problem, now you've got to pay arrearage and you've got to pay your regular mortgage. But an automatic stay goes into place and it stops the sale. And as long as you are complying with the plan, then you're bringing the loan current by paying the arrearage through the plan. And then you keep your regular mortgage payment. When you come out of the plan, then you're current. That's hard. We don't see a lot of success in Chapter 13s when people have to do both, when they've got to pay mortgage and pay, the arrearage. But that's what, in essence, what you're going to do in a bankruptcy. A Chapter 7 bankruptcy, you're not paying anything back, but by the same token, you're not curing your arrearage. So you still got to cure the arrearage. If you're going to keep the property, then you have to claim, you have to agree that reaffirm the debt and pay that debt. So 7 is quite different, but most people that are facing foreclosure use a 13. So they get that automatic stay.
Right. So on our little graph here, we've got a little thing called foreclosure defense. So in a judicial state, and right, that's a whole different monster. In a non-judicial state, what's foreclosure defense in a non-judicial state?
So in essence, we first would look at a mortgage and see some of the mortgages have language in them that actually say you have a right to bring a lawsuit to assert defenses to the foreclosure. So let's say you have a foreclosure that's set to occur on November 1, and you have a mortgage that has that language in there. When we can't for some reason get the servicer to postpone the foreclosure by trying, we're not in the process. We haven't started our loss mitigation process yet. We didn't do it in time. We need to stop the sale. We try to get them to stop the sale voluntarily. They won't agree to do it. If you have defenses, for instance, you say, look, they're saying that my escrow is $6,000 short and they charged me for insurance and I already had insurance in place. I don't owe them $6,000. That's caused my payments to get all out of whack. I don't believe the amount that they're claiming from me is correct, and I shouldn't have been put in foreclosure because my payments were overinflated. That'd be a defense. You would have to actually bring the lawsuit against whoever's trying to foreclose, whatever the entity is foreclosing, and assert the defense. Kind of like, okay, you're in the position that they're not suing you, but it's like they're suing you and you have to defend what they're doing. So in this case, you would file a lawsuit. You would assert your defenses to the foreclosure ahead of it to say, these are my defenses. I don't know who you are. You don't own my loan. And this happens because loans get transferred. I don't owe you the amount you claim that I owe you. You didn't give me the FHA loss mitigation I should have received. You didn't give me an opportunity under VA, whatever the loan is. You assert those defenses ahead of the foreclosure. We also have people that come to us after a foreclosure sale has happened. And it's not really, we call it foreclosure defense, but really in essence, now at this point, we have to try to reverse a foreclosure sale that happened. So now you have to set aside and void a foreclosure sale, and you still bring forward any of those defenses. Okay. So it's a little complicated. It gets a lot more complicated once the sale happens and trying to unravel it. But in essence, the foreclosure defense that you have listed here, in my view, is what you would assert ahead of a foreclosure to say, I'm defending it before you go forward with it. If you go forward with it, now I have to reverse it. I have to ask a court to set it aside. and say that the sale was a nullity because something happened that they didn't comply with, that they didn't do something correct when they did the sale or before they did the sale.
Again, I followed along with you there, but I don't think the average person that heard that is going to be able to follow along with that. Can off the top of your head, you know, you mentioned some things there real quickly, but what's I don't know. Can you give me three things off the top of your head that really caused a foreclosure to occur that was clearly inaccurate or wrong or whatever legal term you want to use there?
Yeah, I can give you, for instance, you have an entity that you've never heard of that all of a sudden is trying to collect from you. Okay. And you doubt that entity even has a right to collect the debt from you. You never heard of them. All of a sudden they pop up, and this happens. We call them zombie mortgages. They pop up. It's like, I haven't heard from anybody on this loan in 12 years. And all of a sudden I've got somebody telling me that I owe them money. I thought it was a scam when I first read it. Now I've got somebody telling me they're foreclosing. So one defense would be, you don't owe my loan. So that would be a defense to a foreclosure. You have in some of these mortgages, and again, that's one of the reasons we have to know who owns the loan. We have to see the mortgage, but some of the mortgages have specific steps, like step A. You got to go to A, then B, C, and D is foreclosure. If they did not comply with step A, for instance, you have to give the borrower a notice of the default and tell them, hey, you're behind, you owe X number of dollars, and they have to give you a date of not less than 30 days to cure the default. Okay, that's step one. And then also they have to tell you in that notice or in a separate notice, you have a right to bring a court action, to assert a defense to this foreclosure. You have a right to reinstate. And if they don't do that part, then they can't go to the next part, which is what we call acceleration, which is where they say, okay, now you didn't cure. You now owe us $100,000 because that's what's due on your loan. And then if they can't, they've got to accelerate before then they can foreclose. So each step has to be strictly complied with in Alabama. Okay, it's different in Florida. Each step has to be strictly complied with. So if they don't comply with those steps, that's a defense. Another example of a defense, for instance, is if you had, say you had an FHA mortgage and you were entitled to a face-to-face meeting, or you were entitled to be reviewed for a specific loss mitigation program, and they didn't offer that to you. Okay. But they went ahead and said, oh, we're going to go ahead and foreclose. We're not messing with it. We're not even going to look at this. That'd be a defense, because FHA loans have conditions precedent before the secretary. They have to follow what the rules are for the Secretary of HUD. Those mortgages have specific language in them. And the defense would be, you didn't meet a condition precedent before you went to the next step, because guess what? We don't want to take people's homes. That's why it's in there in the loan agreement. Comply with that or don't go to the next step. So those are examples of some of the defenses that you could have. And you would put that before the court, and then the court would look and say, okay, let me see, do I think the lender's complied or not? Is this a good defense? Is this not a good defense? And the court has to sort that out. But that's how you put the defense forward ahead of a foreclosure in a non-judicial state.
And of course, you've touched on a lot of what some people would call consumer protection attorney or consumer rights attorney. And that's that whole alphabet soup of the FDCPA, the FCRA, the ABC, and the XYZ. Can you touch on and again, what you're telling me is a lot of those consumer statutes you use in your practice regularly as well. But if you could just explain some of those other statutes that offer those protections.
Sure. So normally before there's a foreclosure sale, you're going to get a notice. Here's one here. A notice that's going to come from a law firm. It's going to tell you, hey, there's your property's going up for non-judicial foreclosure sale. Your foreclosure sale date, for instance, in this one is November 12th of 2024. And they also usually enclose an accelerated amount also, and it'll say, okay, you need to pay $200,000. Okay, because you still, under this particular mortgage that I'm working on here, the mortgage gives the person a right to reinstate. And they can reinstate up to 5 days. And reinstate means you have to pay the whole amount, right? You got to pay everything, and you've reinstated that mortgage, everything that's due. But if they send you a notice that's not correct, and most of these law firms will give you what we'll call an FDCPA disclaimer, and it'll say this is how much you owe. You have a right to dispute this debt, and you need to dispute the debt within 30 days. If you dispute that debt and they don't verify the debt, then you have what we call the Fair Debt Collection Practices Act that protects you from that debt collection. You may have a claim for that. Now, that doesn't necessarily mean that you don't have a foreclosure. That's just a separate statute where there could have been some kind of violation on the debt collection because the number was wrong, because they didn't verify the debt itself. That would be an example. And we see that language a lot when you have these foreclosure notice letters coming in that gives you the amount. So I always tell people, if you get something like that in, take that opportunity within those 30 days and make that dispute. And that makes the law firm then, or whoever's giving you the notice, go back to the creditor to verify that that number is correct. And then they have to give you that information before they can move forward, because if they've given you an incorrect number, you've made a dispute, they have to stop the debt collection until they verify that. Another tool that we have is what you're calling these ABCs. It's RESPA. RESPA is a large consumer protection statute when we're dealing with mortgages, and it's mainly going to apply when it's your residential property. That's where we get the most protections. So that's probably too vast to go into if you have a specific question. But we talked about loss mitigation, for instance. And as you know, under RESPA, if you've started loss mitigation and there's not been a foreclosure sale set, they have to complete the loss mitigation review. If you've submitted what we call complete application, they have to do the review, complete it, and everything before they can foreclose. Now, there's some other deadlines and things that we can get into, and the closer you get to a foreclosure sale date, the less protections that you get under RESPA. You can lose some appeal rights. You can lose some of the protections for what we call dual tracking and things like that. But there's good protections under RESPA. Again, that's another reason why you want to get ahead of this, get ahead of the game, and don't be waiting till the last minute, because then we're scrambling around trying to figure out how are we going to save your house.
Right. And as you know, it's a lot more forgiving in the judicial states. Those processes take a lot longer. And as you know as well, most people go out there and wing it and try to do it on their own. And I'm sure many, many, many people are successful doing it on their own. And here I'm talking about getting a loan modification, but having somebody right, not, but having somebody that understands a lot of this stuff, because I don't think I don't think that guy exists, right? I don't think there's a guy out there that is an absolute expert at everything. Having somebody that, like yourself, that knows, right? Like you said earlier, bankruptcy. I know plenty of bankruptcy attorneys. I work with a bankruptcy attorney at any time, but the way you practice, your experience on the ABCs and understanding the foreclosure courts, and most importantly, understanding your courthouse, right? Understanding how to navigate that is something that it's very, very tough for somebody to try to do on their own. So I'd like to get back to the do-it-yourselfers, right? Because it's, again, I can understand people do it, but they don't. It's impossible for average consumer to dot all the I's, cross all the T's. And then the other big thing is, where do you find help, right? It's average person jumps on YouTube, does some Googling, and it's tough to find help.
Oh, I mean, look, I have people that'll come to me that'll say, "Hey, I found this firm in Pennsylvania, and they did an audit for me, and oh, okay, look, they gave me 32 flags on my mortgage, and I think I'm going to be able to get my house for free." Okay, $3,500 you paid them. This is a piece of garbage, and it's something somebody ran through a computer. But people are desperate, and they're looking for any kind of help. That $3,500 could have been well spent and probably saved their house by going through the proper channels, having somebody review, what the program is, where they are in the process. And sometimes when you didn't get yourself in the place you should have been, right, to give Bobby a chance, if Bobby's trying to help with a modification and run these applications and see what programs are out there. Maybe you get a chance to stop that sale because we talked about RESPA, and there's some other ways to do that through notice of errors if we see something's wrong. To kind of put a halt on it for a minute, if we can just find a way to have the servicer say, okay, let's take a break for a moment. While we got that break, now we're working, try to get that loss mitigation application in. People are desperate and they spend money on, I don't know, it really drives me crazy when I see this happen. Or they talk to some attorney that's in New York and we're in Alabama, and they've paid the attorney money to do something, or they've paid some company. I've had this happen too. They've paid some company. Oh, well, they filled out my loss mitigation application for me. And I look at it and I'm like, a 4-year-old could have filled this out better than what you paid this person to do, because they don't understand. They didn't even complete it correctly. So there's a lot of information out there. There's a lot of misinformation out there, and people need to be really careful and make sure that who they're dealing with knows their game, because you don't want to be playing checkers over here and they're playing chess over here. And that seems to happen a lot.
Absolutely. And you and I could go on forever, but I think that's a magnificent place to stop. And hopefully we could do a couple more of these on very specific issues in the future. I want to thank you so much, Rhonda.
Yeah, thank you for having me.
All right. Have a good one.
Okay.